I think we'll start and we'll let people just trickle in as they have time to do so. The enrollment's about 160, so we're a little light at the moment. Welcome to Trials Without Tribulations, both in Toronto and in Hamilton, Niagara, and Thunder Bay, where the program's going out live. And my name's Sheila Holmes, and I'm one of the co-chairs. Another co-chair is Julie Hannaford, who will be speaking to you this afternoon, and Adriana Doyle, who also will be speaking later. I'd like to also thank the co-sponsors, the Advocate Society, the Law Society of Upper Canada, and the County of Carleton Law Association, where the program was first developed, i.e. we've cribbed quite a lot of it and made it fit into what we wanted to do here today. There will be a question and answer period later, and I'll give details of that via the ILN sites at about 4:30. And the questions, it is important if anyone here has a question that you go to a microphone. We will set up 4 microphones so that the people in the remote locations hear your actual question as well as the answers. If you haven't already done so, could you turn off your cell phone or put it on a vibrator? And the sponsors would particularly like it if you would complete the evaluation forms. The program is being videotaped, and as such, the video may pick up mannerisms of people in the room or voice, and I've just been asked to point that out to you. I'd like to thank both the co-chairs, Adriana Doyle and Julie Hannaford, and the faculty in organizing this program. Given the size of the faculty, you'll realize, and combined with the difficulties of organizing lawyers even to have a conference call, it's been a little bit like herding cats on occasion. In order to make the most effective use of our time today, we will not be introducing individual speakers. You have copies of biographic sketches of the speakers, and they will simply just introduce themselves by name. There is one change to the program. Adriana Doyle, who's co-chairing the program, her flight is delayed from Ottawa, so Julie Hannaford will be doing the initial contact with client that says it's Adriana on your program. This program is based on the family law rules, which, as we all know, are used in some courts and not others. Many of you are well familiar with the rules. Some of us, perhaps all of us, still operate under several sets of rules in various courts. Some counsel are opposed to the introduction of the new rules, but they are intended to provide uniformity on family law matters throughout the province. And guess what? Whether you like it or not, they're coming in. The architect, essentially, of the rules is the senior justice who's going to ensure that they're in place for family law is Madam Justice Mary Lou Bonotto. And I'm pleased to ask her honor to be the opening speaker at this program, Trials Without Tribulations.
Thank you, Sheila, and thank you for inviting me to give these brief remarks. This is an incredibly dynamic time for family law. As you've heard, the family law rules are ready to be implemented throughout the province, and the date that has been established by the Council of Regional Senior Justices is July the 1st. In addition, both levels of government, the federal and provincial, have indicated a desire to expand the family branch of the Superior Court. Last but certainly not least, as of last week, the Superior Court has affirmed its commitment to the assignment of judges in family law who have a strong commitment to and experience in family law. Judges who have a particular interest in and aptitude for family law will be assigned to family law cases for a sufficient amount of time so that case management can be effective and can work. This, I can tell you, is fundamental to the philosophy of the family law rules. The irony is, as we sit here, embarking upon 2 days with respect to family law trials is that the purpose of the rules is to encourage cooperative resolution and to discourage the adversarial techniques for the disposition of family matters. So I ask, what does that do to trials? What does it do to advocacy? Have these issues disappeared from family law? Absolutely not. It is just that the challenge for you as family law advocates is very different. You are going to have to adapt to various tasks within the conduct of a family law case that will, from time to time, seem to be in conflict with each other. There was a day when a good family law lawyer was a good trial advocate, and nothing more. Today, much more is required. You have to draw on a myriad of skills to perform all of the functions demanded by the rules. The primary is the case conference. The case conference is, for those of you who work in Toronto or in family branch sites, will know that it is the cornerstone of the family law rules. In a case conference, you work with your client, with opposing counsel, with opposing counsel's client, and with the judge to find solutions that involve the parties in the outcome. This brings with it, or this demands, a very special set of advocacy skills. Skills that, Madam Chair, I urge you to consider at another series of lectures, not this one. The most effective advocates in case conferences are those who work together with all of these people towards a resolution. But these lectures over the next 2 days deal with the trial, where an entirely different set of skills is demanded. They are not inconsistent with your case conference skills, they're just different. Hence, your program today poses the question, how to run a family law trial. At the risk of being trite, I'll answer that question. You run a family law trial like a trial. It is, ladies and gentlemen, like any other trial. A trial where rules of evidence and techniques of great advocates shine. That is what you're going to be looking at for the next 2 days. But if I can proffer my own remarks about what is unique and what you need to be particularly aware of as family law lawyers, I will do so. I venture to say there's one pitfall for family lawyers who enter a trial, and that is the risk of over-identifying with your client. I say that not just on my behalf, but on behalf of all of my colleagues who have done family law trials and repeat that same criticism. It's an understandable situation to be in because, particularly if you're operating under these rules, you probably, if you get to trial, have been conferenced to death. You believe that somebody in the process is being totally unreasonable and you are annoyed. You may take it personally. I pray, let it go. Walk into the courtroom as an advocate, as a professional, and while you can passionately believe in your case, when you cross the line and identify with your client, you lose your professionalism, you lose your objectivity, worst, you lose your judgment. You sabotage your case, and believe me, all of this is telegraphed to the trial judge. So, prepare, and prepare. Like any other case, know your case, know the rules of evidence, don't lose your objectivity. Now you may say that you may go for years without a family law trial. And there's nothing wrong with that. It means that you're doing a good job of resolving your case. What if you want trial experience? Well, I have a proposal to make. There are, throughout the province, what I call the forgotten family law cases. These are the child protection cases. They are cases where children, through no fault of their own, were simply born into difficult circumstances. The biggest problem that we face in meeting the very strict timelines to have these cases decided is not the availability or willingness of judges or courtrooms or staff. It is the lack of parents' counsel. There are just not enough qualified counsel willing to take child protection cases. The reasons for that are understandable. The pay is lousy. It's a difficult work. The clients are often hugely problematic. But having said that, you, the people in this room, practice family law because you're a unique type of person, and I'm sure you don't do family law because of the money. I'm asking you to do the right thing for these children. I'm asking each of you to take one child protection case a year. It's difficult work. The legal aid rate is low. As I mentioned, the clients can be very difficult. Some have no phones. Some have great personal challenges. But the issue is the children. And we could have easily been born into one of those families as into the families that we were born into. They are our responsibility. They are really all our kids. You'll be giving back to society, and ladies and gentlemen, you will be getting a lot of trial work. So, with that little paid commercial announcement, I ask you to keep that in mind as you consider business valuations and pension issues and income tax issues, that there is another type of trial that needs you. Actually, at the end of the day, I have no doubt that you will get back far more than you will put in. I'd like to congratulate the organizers and the presenters for this program. And I want you to remember that while family law is very different, there still is law in family law. And that's what you're going to enjoy in the next 2 days. Congratulations and enjoy your program.
Thank you, Justice Bonato. As you can probably all see, I'm Julie Hannaford, not Adriana Doyle. And for some of you, that may be a huge disappointment. For all of you, it should be a huge disappointment. I'm going to do the best I can to talk to you for 5 minutes about the initial contact with the client. Now, in your materials, there is a very excellent little paper. It has a précis of very helpful points. The points deal with what should happen on a first interview, what the things that you might fruitfully do, how long the first interview might be. I'm not going to talk to you about any of that. I'm going to talk to you about the 3 questions that, in my experience, make for a fruitful client relationship. And these questions are separate and distinct from the cases that Justice Bonato has talked about that hopefully we're all going to take up at least one a year, namely the child protection cases. I just want to talk about what, in my experience, are the questions, the calculus, if you will, that should go through your mind when you are in that heady initial meeting with the client that's going to be paying you. So the first question is, odd though it may sound, does this client really need a lawyer? And although that sounds odd, as I'm sure all of you must be aware, people come and visit themselves upon lawyers seeking to have an intensely personal domestic conflict resolved. And in fact, often there are agendas and issues and problems going on that a lawyer is never going to fix. And there may well be a number of times where what the client needs way more than you is someone that you are not. You are not, unless you have your specialist designation or the FRCP after your name, you are not a psychiatrist. You are not a social worker. You are not a friend to this client. And there are many, many times when what a client needs, most of all, is a very good therapist, or a very good social worker, or a very good friend. And while they may need that concurrently with a lawyer, with needing a lawyer, it may be that any contact that you have with that client should be premised on concurrent contact with a therapist, a social worker, or a very good friend. The next question that's part of the calculus of what ought to be going through everyone's mind, in my view, is, does this client need me as their lawyer? When clients came to me in my early days, I wanted all of the clients I could get because I needed all of the money that I could make. And I needed to build a reputation, and I needed to get experience. The biggest mistake, of course, is realizing, first of all, for example, that realizing that either this case is too complex or too simple to warrant representation by you. It is invariably easier to refer a client out at the get-go than it is when you're halfway through the case. There are many times when it is worthwhile bringing in co-counsel. The worst nightmare that can happen is when you're on the eve of the big case conference, the big pretrial or the trial, realizing that there are issues that might well have worked if there was a partnership with either other counsel or other professionals. The third question that is an important question, in my view, a key to success, is even if this client really does need a lawyer, and even if they need me as their lawyer, do I want this client as my client? And the questions, the reason why that's important is that generally speaking, when you're signing up with a client, as you all know, this is not a one-off. This is a person with whom you are going to be spending, at times, many hours in a small room together, talking, perhaps at times disagreeing, often at loggerheads, and very frequently educating. If there isn't that chemistry, if there isn't that ability to interact, it's not going to work. And that is the client who will ultimately have problems with one's account, with the lawyer's account, and who will be dissatisfied. I am told by the Law Society when we do the programs of the New Lawyer Experience that something like a huge percentage of negligence claims and or complaints at the Law Society derive from failure to communicate, bad communication, which has a large meaning. I want to suggest that at the initial meeting with the client, that potential difficulty can be determined and should be determined. If the chemistry, to use an overused word, isn't there, it probably won't develop over the next few years. And if it's not there, consider carefully whether you necessarily want this client. And I realize that runs counter to the theory that you've got to keep your billables up and you've got to keep the dockets going. But there's nothing that will tank a good practice 6 months from now than a client that you can't communicate with. Some of the sub-questions that go into that third question should be, can I work with this client? Number 2, can I fix the problem that this client has within a budget? And number 3, am I able, in this initial meeting, to educate this client about the problem that they're having? In other words, can I explain the law? Can I explain the facts and issues that will pertain? Can I explain what is involved in the process? And am I getting the satisfaction that the client is understanding? So those 3 simple questions I want to suggest to you may assist. In my view, they absolutely will assist, if you answer them honestly, in developing a practice, a portfolio of clients with whom you can have a fruitful relationship and through whom you will develop a sterling reputation as an advocate. Thank you.
Good afternoon. My name is Judith Nicole, and I've been asked to speak on pleadings. It is appropriate to follow up Julie's comments on any discussion with respect to pleadings, because it is in that initial consultation when, having determined that you'll keep this client, you need to turn your mind to just how it is that you will frame a cause of action for them if you are called upon to draft a pleading. It is very important that as you discuss this with the client, that you understand whether or not, as Julie has pointed out, the remedy that they're seeking is available in law. At this point, when you're still coming to know the client, it is important to try and get as much background information as possible so that you may have an opportunity to develop what will become the pleading. Assuming that you have then exhausted all settlement possibilities, you should start by finding out what your client's objectives are, and of course whether or not those objectives are obtainable in the law. Without prejudging the case, it's imperative that a lawyer reviews the objectives of a client in order to assess whether or not what the client is seeking is realistic. In my experience, you do no client any good if you indicate to them that you can get them sole custody or can get them $10,000 a month, if that's just not likely to be sustainable. It's important to have realistic expectations from the outset, and of course that starts with your pleading. What we sometimes forget as counsel is that although we do these pleadings day in and day out, for the client, this may well be the only document that tells their story, or at least the first document that tells their story, and they take it quite seriously. How many times have you had people call your office in horror, having received a petition that says that the spouse wishes to have them restrained from molesting or harassing? These words send chills through the spine of the reader, but of course to us it's just the standard language under the Family Law Act. So it's imperative that we understand what it is that we're doing for the client and that we've put appropriate claims within the pleading so that when the client comes back and wants to know why they don't have sole custody or why they don't have $10,000 a month, they can understand that the pleading was a starting point and that you have explained to them what the pros and cons of their case is and what will be realistic, notwithstanding that you may have put in overly generous claims within the pleading. I think early on in your career you need to develop your own style when it comes to writing these documents, because I think first of all you have to decide whether or not you're going to be of the everything but the kitchen sink variety, where you put every possible claim into the pleading and hope that something will stick. In my experience, I don't recommend that. Certainly I don't suggest that one limit one's client's options, but by the same token, there's nothing to be gained for asking for claims which are simply not appropriate in the circumstances and which are not likely to be successful. I think if you are, oftentimes when you get the defense from the other side, you'll see just how the uproar that you can cause by putting in claims which really have no business being in the document. It's important that you plead in a concise and organized fashion. This includes trying to avoid being overly technical in your pleadings, and of course, in all areas of legal writing, the tendency is towards simplifying matters rather than getting highly technical and complicated. Without dumbing down the document, it's important that it's understandable to all of the readers, including your client and the judge that will have it in front of them at some point. Where possible, it's useful to use headings in order to organize the pleadings and to plead in an organized and straightforward manner rather than throwing everything in and hoping that you touch all the bases. I think you have to resist the tendency to be too literary in your writing and pleading non-material or unduly repetitive facts. How many times have you seen a pleading that's 20 pages long, claiming the same thing throughout and repeating the truth 1,000 ways? This only serves to take everyone's attention away from what matters and is to be avoided. In every case, you want to look at what your proper starting point is. You want to look at the statute, the case law, to determine what are the fundamental elements that you need to prove in order to establish your case. Then you try to craft your document in order to fit in within both the legislation and the current case law. Familiarity with the case law is essential so that you can understand what's appropriate. For example, there's no point in trying to plead that you're going to set aside a separation agreement if you haven't had at least a passing acquaintance with the most recent decisions. Prior to pleading in an answer, it may be appropriate that a demand for particulars is prepared in order to ensure that you have sufficient information in order to prepare your own pleading. Make sure that you fully understand what it is that the other side is seeking before you put in your own claim. As you have to be careful, as Darlene Summers points out in the paper that's included in your materials on pleadings tips, under the family law rules, the temptation can be to get, in the forms that are provided, they invite you to draft in the first person, and you have to resist the temptation to make every document look like an affidavit, because certainly the application is not meant to be that, and the same rules of good drafting should apply in that document as in any others. Your pleading should contain a concise statement of the material facts upon which you rely, and so it's important that you set out all of the essential elements in order to establish the claim that you're after. It's insufficient to simply plead, for example, that your client is entitled to spousal support without including the basis upon which he or she is entitled to that, having regard to the law. So some basic statements as to that the spouse stayed at home with the children or contributed to the other party's career would be in order. You shouldn't, however, plead all of the evidence by which you intend to plead to prove your factual assertions. That can get to be a bit gray, and counsel often ignore this rule, but again, otherwise you end up with everything looking like an affidavit. Conclusions of law can be pleaded if the material facts supporting such conclusions have been first pleaded. You should also refrain from pleading prejudicial, frivolous, or vexatious matters, failing which, in the worst case, the pleading can be struck. Again, this is also a stylistic thing that you need to decide early on in the piece as to how it is that you're going to write. I think that some people's documents tend to be more hysterical than others. And again, as Julie was saying in her discussions about the first meeting with the client, and Her Honor Justice Bonato was speaking at the outset, you have to take a step back from your client's wishes and ensure that the document is a professionally styled document that doesn't, while certainly conveying the importance of the matter to your client, doesn't convey any hysterical element that may go along with it. It is better to be persuasive by being right than by being loud. It's a good idea to use precedents, but don't be a slave to them. So it's not unusual to get somebody else's document and wonder what a particular paragraph has to do with the circumstances of that case. Undoubtedly, it's because somebody stopped reading the last precedent as they were roaring through their work and didn't delete something that shouldn't be there. So make sure that you've pressed all the buttons before your document goes out on behalf of that client, because you want to tailor it to the particular needs of that individual. You also want to make sure that you have sufficient particulars so that your opponent can respond and you won't be faced with your own demand for particulars. Some specific defenses have to be pleaded, such as a limitation period. And of course, it goes without saying that it's critical to remember that unless you deny a specific factual allegation in the claim, you're deemed to admit it. Now, there are a number of rules in both the family law rules and the rules of civil procedure dealing with amending your pleadings. I won't go into them at length because I note that Jim Herbert is going to be speaking about that a little bit later this afternoon, but I would just emphasize that it is very important to review your pleadings from time to time. Often you'll be called upon to prepare a document quickly, and you may not have the full story as it will unfold once you've had a chance to hear both your own client's further information as well as some of the information from the other side, whether that's through their own material or through examinations. You do the best as you can in the early stages of an action, but it may be that along the way you discover that there are other elements which have not been pleaded, or there may be changes in the law that couldn't have been contemplated at the time that you were doing the document. So it's important to just take a look at the documents again and again, and certainly at the very least at every step of the process, including at examinations and immediately after examinations. That's probably one of the best times to be looking as to whether or not you should amend once you've had a chance to know whether there's anything further that should be added. Amendments can be made all the way up to trial, but obviously it's better for all concerned and certainly better for settlement prospects if you've made any amendments that are required earlier on in the piece. A party can amend at any time unless it's deemed to be too prejudicial by the court and cannot be compensated by way of an award of costs or an adjournment. You can, as I've said, even amend up at the trial. However, what you want to avoid making numerous amendments because it does tend to make you look somewhat disorganized and certainly unclear on what the position will be. The responding party, of course, must file and serve their amended defense within the time prescribed, failing which their original response will be deemed to continue. The main thing to remember in whether you're pleading under the family law rules or under the rules of civil procedure for at least another little while is that the rules do apply and that we must be governed by them. The family law lawyers are often criticized for not having as highly developed a sense of the rules of civil procedure as they should have, and sometimes with no justification, other times not. But it's good to become familiar, and hopefully once we're all on the family law rules, that we'll only have the family law rules to contend with as we're doing our drafting. But keep them in mind, know what your obligations are, and in that way you'll be able to have a document that will satisfy both your client and the court. Thank you.
Good afternoon. My name is Lori Politza, and I am here to talk to you about the preparation of financial statements, which when I was assigned that topic, thought this may possibly be one of the most boring topics ever to have to give a speech on. However, I actually got quite excited about it. So first of all, let me just have a word, say a word about the importance of financial statements. I've been experiencing, both in my own practice and in seeing what's happening on the other side, that there is a tendency to pay a lot less attention to financial statements than we used to, especially on support issues and budget issues. Council's inclination, I think, is to simply take the financial statement, look at the spouse's income, the payer's income, run the table amount, find out what support's going to jack it up to 50%, and then don't pay attention to the expenses in the budget. It's convenient to do that, without question. It gives you a range on what you're probably going to be looking for, but it means that you're lulled into a sense of security and into a thought that you don't have to justify your numbers. And frankly, of course, your client is doing a sworn document, and we all know that that's just plain wrong. If there is any doubt about how wrong that is, let me tell you why we should recall what the situation is, and that is there are 2 recent Court of Appeal cases that have been released that remind us of our obligations with respect to financial statements and how important they are. The first one that you're probably familiar with is Marinangeli and Marinangeli, or as some say, Marinangeli, but whatever it is, it was released in July of this year. And basically the situation was the following. In May of 1996, in a pretrial memo, the husband said that he anticipated a reduction in his income. The financial statement, signed the day before the minutes of settlement, had the standard clause saying that the husband did not anticipate a material change. The financial statement talked about the husband's options and also some phantom stocks, and with respect to his options, said that the value was unknown and gave a little bit further explanation. With respect to the phantom stocks, it said that that if it was taken into account as income as well as property, it would be double dipping. The question that arose is whether the husband had an obligation to disclose the material change when he cashed in $1 million worth of options over the course of the next year, to disclose that to his spouse. And the Court of Appeal agreed with the trial judge, saying that there could be a term implied that in these circumstances the husband had a duty to disclose. And the reason that that's important is set out in the case, and I'm just going to read you a little excerpt. It says, one of the documents that forms part of the factual matrix when the minutes were signed is the financial statement. That document indicated that the appellant had stock options that were a contingent asset whose value was unknown. The disclosure in the financial statement respecting the stock options is indicative that the parties did not intend the value of the options to be taken into account in respect of support at the time they entered into the agreement, but only if and when they were exercised. Read together and as a whole, the minutes and the financial statements are indicative of an intention that the appellant would disclose a change in his financial circumstance. Who'd thunk it? Certainly not me. What's the lesson? The lesson is that those little innocent explanatory statements in your financial statement can have a significant difference and make a significant difference, and the court may well rely on them. So think about the notes, for example, that you're putting in your financial statement. The other case that I'm going to bring to your attention was released 2 weeks ago. It's a case called Contino and Contino, a case under Section 9 of the Child Support Guidelines, and you'll all recall that Section 9's that 40% rule case, and you're obliged, if you want to deviate from the guidelines, and you have more than 40% of the time, you're obliged to look at the table amount, look at the increased costs of shared custody, and look at the conditions, means, needs, and other circumstances of each spouse and any child for whom support is sought. What's important with respect to Contino is what the court had to say about financial statements. And when they talk about Section 9B, they say, if that parent wants to show that the increased costs of shared custody has resulted in some extra fixed cost expense, such as larger living quarters, he or she must adduce evidence to that effect. Depending on the nature of the additional cost, the applicant parent will be entitled to a reasonable reduction in the support payment. And with respect to the conditions, means, needs, the court says the following. Where a parent who has been paying support brings an application under Section 9, the court should make a common sense assumption that the responding parent's fixed costs have remained unchanged, and that his or her variable costs have been reduced only modestly by the increased access in the absence of evidence to the contrary. And then they go on to say the absence to the evidence to the contrary would be in a child expense budget, and they say that that's particularly important. So I draw those things to your attention because even though we may be letting budgets fall by the wayside and being not so careful, it's very apparent that the courts take a different view. Now, I'd like to tell you briefly my top 10 tips on financial statements and in the preparation of financial statements. I've got a couple of general, and I didn't deal with them in my paper as a top 10 because I wasn't that organized, but I thought that when I was actually preparing to speak today that there actually probably were 10 issues that I'd like to canvass with you. The two are just general comments when you begin to prepare a financial statement. And the very first one that sprang to my mind is the issue of the valuation date. And our tendency, I think, as counsel is to say to your client, when did you separate? And they give you a date, and you use that date. And of course, we should all know, but sometimes forget, that first of all, you should be explaining to your client what the valuation date means. And of course, you can have two different dates of separation for the purposes of a valuation date and the date of separation for the purposes of divorce. So make the inquiries. Determine what the date was that the spouses separated with no reasonable prospect of resuming cohabitation. That gives you the valuation date. They may have reconciled, though, so they may have a completely different date for divorce. Don't forget that. That's important. Next issue is get backup on the financial statements. When your client has expenses, ask them for backup. When you're setting out items on the financial statements, ask for backup. Put it in a brief. That way you know what's been disclosed to the other side. And I tend to take over a lot of files from other lawyers, and it's very clear that people have wildly different approaches as to how and how much time they spend with their clients preparing their financial statements. But under no circumstances do a financial statement without getting the appropriate backup. Tip number 3 is on the issue of income. You can see I'm going through the financial statement as we would ordinarily fill it out. Again, don't just assume that your client's last year's tax return is the income you ought to put on the financial statement. Be strategic about what you're doing with income. Think about it. You can either choose the last tax year, you can choose something prospective. What if your client's a commissioned salesperson and having a dreadful year? Use something prospective. If it's beneficial, think about using a 3-year average if your client's income goes up and down. If your client's got a closely held corporation, are you at risk for pre-tax earnings in the corporation? Should you be thinking about that? So don't, again, simply accept face value as to what you should be putting in the income figure. With respect to expenses, think about the period of the budget that you're doing. Some people just automatically take the last 12 months no matter what. That may or may not be appropriate. Are the spouses in the same house, and did somebody move out over the course of the last year? If so, maybe you want to take the last 4 months and do the balance prospectively. If there has been a significant change since separation, i.e. someone's bought a new house, then perhaps you might just want to reflect the expenses in the new house. If your position that insufficient support is being paid and you don't want to show that, do a proper actual budget disclosing what your client is spending now, and then do a proposed budget showing the lifestyle. But don't forget about those issues. Don't necessarily have your client running an immense deficit, which brings me to the next point, the issue about deficits. All too often, we see financial statements prepared that have a significant deficit. You have to ask yourself, when your client comes in and is running a $20,000 deficit a month, well, how are you meeting that deficit? And unless someone is taking out a significant amount of loans, has built up credit, or is getting gifts from someone in order to sustain themselves, then frankly, question the veracity of your client's numbers. It's the most easy thing to cross-examine on, and you get people every single time. So if indeed that's what's happening, again, put what your client would like to spend in a proposed budget, use the actual figures in the actual budget. The next issue, as we move through the financial statement, is with respect to the issue of property. And you'd like to think that your client would tell you about all the property and the use of property that they've had over the course of the years that they were together. And I always ask my clients about what access to property they have had over the years. And by that I mean, for example, is there a cottage that is a grandparent's that still is in the name of other parties that your client might make a trust claim on as part of this action, and you may have to join another party? Is there a significant increase after the date of separation of property that's in the other spouse's name? If so, you might have a trust claim. Is the couple a common law couple? Then your trust claim. So my view is that you should put the trust claims right in the financial statement. Obviously, don't include them. You can exclude them for the purposes of determining the value of property, but I put them right in the financial statement for the very reason that you want to be able to look at the financial statement and understand to the extent possible what the claims are that are being made. There are some tricky property issues, and how you deal with them in a financial statement is sometimes problematic. I'm a big fan of notes to the financial statement, which I actually like to put not at the back, but right in the body of the financial statement if there's room. One of the tricky things to disclose in a financial statement is if someone has options, because of course, unless you've had a business valuator deal with them and value them, you probably don't have a lump sum figure to put into the property portion of the financial statement. At a minimum, what you should be doing, in my view, is doing a schedule of the options, providing all of the information about the options, the date of the grant, the price of the grant, the vesting schedule, the date the options expire, the current trading price, and don't forget that if you change your financial statement, the current trading price, the today column or the date of statement column is always going to change. So you always have to be checking the share price and updating that. Just as an aside, it's really important also, in my view, to make sure that your client understands that options, even if they're not vested, have value. They must be disclosed, so you have to ask those questions in the first place. And secondly, it's also important that they understand that they're likely to form part of the property settlement, and they might also be taken into account for future support. So you need to be discussing that with your client right off the bat, deciding how strategically you want to address that issue, but be clear with your client so that they're not taken by surprise. On the debts portion of the financial statement, I have a pet peeve, and just so you know, this is number 8. My pet peeve is that people don't look critically enough at costs of disposition. So I find, and in fact I see some of those people sitting right in this room, that of course people are going to try to maximize the cost of disposition, and that's perfectly fair. So if you're in a situation that you've got a client, for example, with a large RSP, I see often notional cost of disposition of between 30 and 35% being deducted across the board. If you actually look at the case law, first of all, the range in the case law appears to be more the 20 to 25% mark, but more to the point, none of those unilateral figures take into account the age of the holder, the retirement age, their likely income on retirement, and so on. So it is imperative that when you see RSPs, you don't automatically accept someone else's figure on cost of disposition. That's issue 1 on cost of disposition. Issue 2 is, does this help me in some way? So if, for example, you've got the other side's financial statement, and they take 35% on their 100 of RSPs, but your client has 200,000 of RSPs, I'd take 35%, disclose my client's RSPs at $200,000, and obviously there is a benefit to your client. So again, think strategically about how you're preparing your financial statement. The last 2 issues are very straightforward, but just a reminder. Number 9 is exclusions. And I talk about exclusions only because, frankly, clients almost always have to be educated that if they want an exclusion, the onus is on them to prove it, And largely clients don't understand what tracing means. So be very clear with your client how they have to trace their exclusion from the time the gift was given right through and up to the current day, to the date of separation. So that's issue number 9. And issue number 10, my other pet peeve, is the category of disposal of property. First of all, too often people don't fill it out. And the other question that is not answered oftentimes, or the client's not able to answer, is where's the money? So if you've disposed of the property, make sure your client is in a position to tell you where the money went, and you've got some documents to back it up. So again, on those issues, on exclusions and on disposed property, I also make sure that my client's documents are together in a brief. So I do have a final word about financial statements, and it's from Contino. So just let me read this little bit from Contino, because Contino quotes a BC Court of Appeal case, which I think is quite instructive. And the BC Court of Appeal, in a case called Green, said the following: in order to apply Section 9, it is important that the parties lead evidence relating to subsections B and C, that is, of the increased costs of shared custody arrangements, and the condition, means, needs, and other circumstances of each spouse, and of any child for whom support is sought. Justice Prouse suggests that the court has 2 options: either to make assumptions as to the increased costs, or to dismiss the application for lack of evidence. So let's think about this. Your obligation as counsel is to ensure that proper evidence is before the court. The financial statement is, frankly, one of your best tools to do that. Use it well, use it to your advantage. Thank you.
Hi, my name's Nicole Tellier, and I'm here to talk to you about experts and expert reports. And I'd like to just start by saying that I think the frequency with which experts are being used in family law matters is on the increase, and perhaps in part because our society is becoming more complex in terms of the financial world, or the world of science and technology, and health sciences. I think, though, that the trend could be dangerous, and we have to be very practical and also legalistic when asking ourselves the question at the outset whether we need an expert, for what issue we need that expert, how many experts we need. So I'm going to talk to you about some of those issues. My job today is to give you an overview of some of the questions that you need to be asking, how you go about selecting experts, the kind of reports there are, the rules that pertain to the different reports, and some of the evidentiary issues that arise. Tomorrow you'll be hearing from Tom Bastido, and he's going to speak more about actual preparation of your witness at trial, and you will, if you're attending tomorrow, also see some demonstrations of that. So the first question is, do you need an expert? And there's a case law on that, but just from an initial perspective, you know, asking yourself the question, do you need one? It's, you start with the first principle that the whole purpose of an expert is to explain to the judge, or as the case may be, not in family law, but in other contexts, the jury, needs specific help with the information in order to draw inferences or make conclusions. And there are many cases, I think, where family law lawyers believe an expert is necessary when in fact it isn't. And I'd like to give you some example of those, because I think you run the risk of being told that the expert is not being necessary, for starters, if you don't meet the necessity test. And secondly, we are painfully aware in this area of law that our clients' resources are limited, and it's very easy to run up $30,000 in a custody and access assessment. It's just as easy to run up a $50,000 fee to retain a financial expert. And so you need to be mindful of the law in the area of when to use one and be practical, so that you still have persuasive evidence before the court, but you don't necessarily become overly reliant upon your expert. The literature and commentary on the use of expert is replete with references to the expert not usurping the role of the judge, so that if a judge can draw inferences from the facts, you don't need the expert. Likewise, the expert shouldn't usurp the role of the advocate. And if you can get the evidence from a lay witness and apply the law, you shouldn't use the expert. I'll give you some family law examples to elucidate that point. And here I think it's a good idea to be mindful of the principle of judicial notice, something that I've always admired Justice Leroux Dubé for writing about and thinking about, which is not often used by counsel. But if there is a body of knowledge in the public domain that is helpful in proving an important aspect of your case, you may be able to get that into evidence by way of extrinsic evidence by asking the court to take judicial notice of certain facts, and therefore you don't need to have an expert to prove them. For example, you may use Statistics Canada evidence to show what the average graduate with an MBA could be earning if he or she was employed and had been out of the workforce. You don't necessarily have to run off and hire an expert to prove your spousal support claim if some of the components of the claim can be found in documents in the public domain. So think about judicial notice and think about ways to get that evidence before the court without the expense and attendant with hiring an expert. Another example, I think, is in income analyses. For example, under the child support guidelines, it's become fashionable for those who can afford it to hire business valuators or other experts to give evidence on the determination of income. Quite frankly, a properly sworn financial statement, a good examination in chief or cross-examination, the proper application of adjustments to income through using the use of Schedule 3 from using the legislation itself, or banking records showing a spending pattern can all go a long way to determining income without spending $15,000 to $20,000 to have a professional tell you that that's really what the income ought to be. Now, this isn't to suggest that you should be shoddy about your case or not use an expert when you need one. I just think that we need to be practical in our choices and not spend a lot of money when the job can be done in more conventional advocacy methods. It's really important with any kind of advocacy that you have a plan at the outset. On the one hand, you're always trying to settle your case, but you've always got that trial date there in the ahead of you to think about. And so it's really important to retain your expert early on, and I can't overemphasize that. Your expert can obviously assist you should you decide that you need one, can assist you in a variety of ways in which might even avert a trial altogether, and they're pretty obvious. An expert can help you form an opinion on one of the difficult issues in the case early on. An expert can help you in the preparation of your discoveries. An expert can attend at pretrial conferences and facilitate settlement. So you need to be thinking about how, about who you're going to hire and get them on board as early as you possibly can. If you have decided that there is an issue that does require expert evidence and your client has the finances to do it, then it's imperative that you do your homework thoroughly. This is probably stating the obvious. I should have asked this at the outset. How many people in this room have done a trial with experts? And how many people have used an expert early on but never had to call them, and that's sort of been... Okay, is there anybody here that has no familiarity with experts whatsoever? Okay, well, then this may seem rather pedestrian to you, but I'll say it anyway. I still think that it's very important that you do the research very carefully. For example, if you have a mental health problem, is your client suffering from a mood disorder? Do you want someone with a particular expertise in mood disorders as opposed to just a general psychiatrist? So it's very important that you do all of your homework, and for me that includes meeting with the expert and making sure that your client meets the expert. They can become the key witness in your case. Unfortunately, their testimony may become even more important than that of the main litigants. And so they may have a beautiful CV and seem to be knowledgeable, but a good expert is not necessarily a good witness. Just like we have clients who have a good case who are terrible witnesses, you ought not to assume that an expert with excellent credentials is going to be a good witness for you. And so it's important that you meet with them, and that if your client's going to be paying that large sum of money for them, that they meet with them as well. There are the obvious uses for experts in family law, ranging from financial issues to mental health issues, and I want to focus briefly on some of the ways in which we use experts in the health sciences field, because there are some more difficult issues in that branch of expertise than in the financial ones, in my view. The first thing is to be mindful of the distinction between expert reports and practitioners' reports, which are governed by completely different rules. So that if you are using a medical expert, you are governed by those rules. The time frames are different, and their evidence can only be tendered with leave of the court. And it is the expectation of the court that the report will actually be substituted for oral evidence. And that can become a difficult call and a tricky issue. So there are a number of restrictions. First of all, we have a general restriction pursuant to Section 12 of the Evidence Act with respect to the number of experts each person can call, that being 3 in support of their case. But if you have a complex case, or rather a case involving a complex mental health issue, which may have relevance to more than one issue in the action, such as capacity to work and therefore support, as well as parenting, you may be wanting to call more than one expert. One of the problems that often arises is the decision about whether to choose a person's treating therapist or whether to choose an independent expert who's been retained solely for the purposes of litigation. And there are problems inherent with both those choices, or choosing one over the other and not both. If you put the treating therapist in the box as your expert witness, you run the very real risk that all the clinical notes and records of your client's course of therapy will be sought and ordered in the trial. As with any evidence, the rule of relevance is obviously key, and if you have put your client's mental health an issue in the action, then it is prima facie relevant to have as much information about the client's mental health status as possible. That being said, the principles under the Ryan decision in the Supreme Court of Canada still permit a court to exclude relevant evidence if its prejudicial effect is going to override it. And the key concern for a court in determining whether to order all the clinical notes and records of a treating physician is the sanctity of the therapeutic relationship. And so you must be familiar with the Wigmore test as modified by Ryan, and make a determination and warn your client that they run the risk that some private information that's in these notes, which really has nominal relevance to the issues in the action, may be made public. And there are ways for the court to control that, and motions that can be brought. But that is a concern that one has. That's not to say that if you hire an expert in the mental health field who produces a report, that his or her notes in the preparation of that report may not also be sought, and you may end up in a voir dire and a fight about whether privilege has been waived or not, and the extent to which the notes that were made in preparation of the report can be produced in the course of evidence at trial. Another related issue regarding medical records and mental health records in particular are that they frequently rely, and this is true of a lot of opinion evidence, but more so I think of this subset of evidence, they frequently rely on hearsay evidence. So evidence that would otherwise be inadmissible but is admissible in this context. And that is, for example, that psychiatrist that you hire that was not a treating physician, the defense medical, may in fact be looking at somebody else's clinical notes and records and doesn't have personal information or observation about that. They may be looking at a clinical record that's some 20 years old. And they are admissible, they're not, and the best case to read and be familiar with in terms of the extent to which the hearsay rule is abrogated or modified in the context of expert evidence is Lavallee. And there's a 4-part sort of analysis that should guide you, and that's a case you ought to be familiar with if you're entering into terrain of expert evidence. The other case that is obviously key is the Mohan case, which actually sets out the 4-part test for whether or not you can actually use the expert. I've talked a little bit about necessity, which is the first part of the test. Do you absolutely have to have this evidence from an expert in order for the judge to draw the inferences that need to be drawn to make the conclusion, or do they need the assistance? The other is obviously relevance, but again, all relevant evidence may be subject to discretion and weighing, and some being let in and some not. The absence of an exclusionary rule is the third part of the test. I'm not aware of any situation that would come up much in the family law context. It comes up much more in the criminal law context. And the fourth requirement under the Mohan test is obviously that the expert is property qualified. And you're going to probably hear more from Tom Bastido and see a demonstration of this tomorrow. But it's important to know that the expert, you can't just necessarily have a psychiatrist to talk about a mental health problem. The expert needs to have the expertise in the field that the court needs the assistance with. So be careful there. Just as a common tactic, and I'm sure this will be discussed again at greater length tomorrow, it's common to gloss over the expertise of your particular expert when you're starting out your examination in chief. Often it'll be a tactic of the opposing counsel to stand up and say, oh yeah, they're obviously qualified, I don't object, and we all know that tactic is to move you along so that you don't draw the expert's attention to the court. But it is really sometimes critical and important to lay the foundation of what your expertise is and isn't about. Don't fall into that. You need to satisfy the test. It will be critical in argument and summation. So don't fall into the trap that everybody's agreeable, that the expert's qualified, and move on. It could be very detrimental to your case later on. I've mentioned that there are different time frames for the filing of the reports, and they're listed in tab 4 at the materials that were prepared for this seminar in Ottawa. It was, this session was planned, I think, with the assumption that the old rules would be soon on their way out. I think they may be here maybe staying longer than we think. So be sure to, obviously, goes without saying, you're going to check the right rules, but also be mindful of those rules in the Evidence Act that I alluded to that are pertain to healthcare reports, as well as the number of experts that you can call. If there's only 4 cases that you read when you deal with experts, I would say it's the Lavallee case, the Mohan case, the Pickard case, and the Abbey case. If you're familiar with those 4 cases, all of which are Supreme Court of Canada cases, they will guide you on the issues of when to use them, how to make sure that you've met the criteria, how to overcome certain problems where you're relying on hearsay, and all of those important things. So I will leave my comments at that. Hopefully tomorrow you will hear more about the actual strategy of preparing the report, preparing the oral evidence, preparing for cross, and see a demonstration of that. Thank you very much.
Hello, my name is Georgina Carson, and I'm going to be talking about questioning before trial. Of course, under Rule 20, I think that was the biggest change from the former rules, is that we now call it questioning and not examinations. That they condensed 131 pages of the Rules of Civil Procedure into 6, which was a miracle, I think. But of course, the biggest change under the family law rules is that you now require leave to question, which truly is a paradigm shift. Although I was in a family rules court approximately a year ago, and my friend asked the Honorable Justice for leave to question, and the judge looked at him quizzically, slammed his hand down on the Rules of Civil Procedure, which was not the appropriate rules in that court, and said, "Son, it's your God-given right to cross-examine." And my friend and I looked at each other and said, "Well, actually, Your Honor, it's not." So it was quite a day for all of us. We all learned a lot. Fortunately, that happened about 10 minutes before the judge made an incomprehensibly high order for child support. And a little light bulb went off in my head, and I said, "Your Honor, you think this amount is tax deductible to my client, don't you?" And he looked at me quizzically and said, "Of course it is. Have they changed the law?" So the administration of justice carries on. At any rate, so does it really happen? Under the new rules then, and I think personally that it's a very good change, that we really should give pause for thought before we go willy-nilly into examinations for discovery at great cost to our clients. We should stop and think, okay, what is the most cost-effective way to resolve this case, first of all. Secondly, even if it appears that the matter is trial-bound, and that there will likely not be much avenue for settlement, never say never, in any event, but is the case, and so many family law cases are, document-driven. We have a number of assets, a number of debts, they need to be substantiated, and most family law lawyers exchange that documentation and the disclosure willingly, often without being asked, of course, and just send document briefs. And a lot of the evidence is gathered in that way, or through correspondence simply requesting documentation and evidence. So you have to think about what the case is truly about. Certainly in family law, there are many cases that you need, where oral evidence is very important, where evidence needs to be marshaled about things like trust claims. You know, what was the unjust enrichment, what was the corresponding detriment, and is there a juristic reason? And much of this evidence needs to be marshaled through oral evidence of the parties. Often the data separation is in dispute, and those facts need to be put forward in an oral fashion, and the stories need to be got out. Sometimes even something like a pension, which you think is going to be put forward by way of expert evidence. Often there may be an actuarial report, but the evidence about the first date at which a party can retire is an issue. You know, one party says, well, we always talked about him retiring at 55, and suddenly, you know, he loves his job and wants to stay on till 65, depending on the values. So there are certainly evidence that may be needed in an oral fashion. However, even then, that evidence can sometimes be sought and replied to in correspondence, or better yet, at a four-way meeting. Yes, it's true, four-way meetings are not transcribed, but frankly, one of the main reasons, in my view, and I would say many litigators share this view, one of the main purposes of examinations are to assess the other party's credibility, their demeanor, their attitude, their responsiveness. And frankly, much of that can be gleaned in a four-way meeting that might end up at a settlement, which is much less costly and more productive for all concerned. So think before you shoot, think before you schedule examinations. And we all know, oh, well, we'll just have a little examination, and the next thing you know, there's lists and lists of undertakings. There's motions for refusals, there's adjournments, there's examinations of non-parties. It just snowballs, and the costs skyrocket. And at the end of the day, so many times, and of course hindsight is 20/20, but so many times people look back and say, well, you know, were examinations really necessary? Am I really going to read any part of this transcript into the evidence at trial? Often, transcripts, of course, are used to impeach credibility at trial, but even then, the usefulness tends to be fairly nominal. So think about whether or not you need to examine at all, and the new rules mandate us to do so. And think about whether or not a request to admit might be a better way of gaining admissions, narrowing the issues. A request to admit is often a lot of work, but it makes you focus on the case. It lets the other side know that you're focusing on the case, and that, and often request to admit can be a good foundation for an agreed statement of facts, which can reduce the length of a trial by days. Now, if you decide that, nope, have to do examinations and off we go, then at least get the other side's case. So many people head into an examination for discovery, and there's no question, especially under the new rules, that I call them new, which is dating me. I know they've been around for a while, the family law rules. Yes, you can cross-examine. There's no question you can cross-examine. But why? Yes, if you can get clean, clear admissions, great. But the fact is, most people who ask close-ended questions at an examination for discovery get flat denials, and they don't get the other side's case. Or the questions are phrased in such a way, and we can all learn from the best litigators, but the questions are phrased in such a way that they can be qualified later on and they can be got out of. And it's far better to have a good sense of what the evidence is going to be at trial than to try to get admissions that you're simply not going to get. It's far better to get an understanding of the case and to ask very open-ended questions like, is that all the evidence you intend to rely on? Which usually, you know, provokes a rather frightened look, as if people haven't thought of something, and it underlines the importance of them disclosing later on if anything new comes to light, and you can ask that as an undertaking in the examination. At worst, there's a slight delay before you get the further evidence. At best, you have boxed them in and you've got a clear understanding of the evidence that is going to be led at trial. And at the very least, if evidence is brought in later on, then it clearly looks like an afterthought, and you can put that to the trial judge, or put that to the witness at trial. So if you decide to proceed with examinations, then it's very important to listen to what the evidence is and not simply go through your list of questions, of course, but to listen to what the responses are and follow up on the line of questioning. So many people, especially when they're first starting out in examinations, have their set list of questions, they don't listen to the answers, and they don't hear the really important direction in which the evidence is going, and then they miss out. Of course, we all leave the door open at the end of examinations saying, oh, well, you know, I'm adjourning pending undertakings, or I'm adjourning pending me thinking of more questions to ask, which is really what that means. But, you know, I recommend, everybody has a different view, but I would suggest that asking open-ended questions and truly trying to get a sense of what the other party's case is very, very important. I do note that under the family law rules that once the threshold is met for examining, if you get leave or you have the consent of the other party, then the rules, if anything, are firmer. It seems to be easier to examine non-parties under the family law rules. A judge can actually make a finding of contempt for a refusal. Usually it's a two-step process. There has to be an order to respond to the refusal, and under the family law rules, it seems like you can, you know, go straight to jail for a refusal. So they're very firm rules. I think very useful rules for examination. But again, I think that the primary thing we should all sit back and do more often is question whether or not we need examinations at all. Thank you.
Hi, I'm Daniel Malamed, and I'm going to speak on two issues, the request to admit and discovery of documents. Both are so scintillating that I'm sure you're prepared to sit for another 45 minutes just listening to me talk about this while the coffee is waiting out there for your break. This topic follows perfectly on what Georgina said, because in effect, if you're asking yourself, should I do a discovery or not, one of the most important things, if you conclude that really it's probably not necessary, then what I have to speak about is critically important to your successful ability to prosecute a good trial, whether you win or not, because we know that's a function of judgment. But in order to do a good job for your client, considering discovery of documents and considering the request to admit are two critical pieces of things you must consider. In the paper that's in the materials at tab 6, it's really just a very brief summary. And I'm only going to highlight what I think are, first of all, some of the differences between the rules of civil procedure and the family law rules. And then I'm going to give you some of my own tips about what I think about when it comes to these two issues. It's important, I'm going to start first with the discovery of documents. It's important, of course, to read the rules carefully on what are documents. And if you look at both sets of rules, the rules of civil procedure give a fairly detailed list of what they consider to be documents. And the family law rules are a little more vague. I actually don't think it makes any real difference. A document is anything that is recorded on paper or by data or by some other means. That would include all emails. That would include anything that of a husband or a wife at home records all their expenses in some kind of computer program. All of those things, to my mind, and I think to the court's minds, are documents. And so when you're preparing your affidavit of documents, give due consideration to how your client has discussed what documents they say they have brought to you and what other documents might in fact be requested. Because there's nothing more frustrating than thinking you finished that massive affidavit of documents and finding out that in fact the other side is aware of, you know, thousands of other documents that you have to then go and rush around trying to prepare because you're embarrassed that your affidavit of documents, which you have certified to be a complete disclosure, as best as your client has told you, isn't in fact the full set of documents. Now, the reverse is true, of course, for you who are asking for those documents. If you get an affidavit of documents and it's missing anything of email, you can be sure that email will have lots of fruit if there's a relationship ongoing with another person. Not so much about the relationship, which might be titillating and all of that, but of no import to the case. But it may have things like, oh, you know, that bank account, she doesn't know anything about it. And you may laugh and say, oh, no one would ever do that. Well, I have a case ongoing now with, I'm looking carefully to see if there's anyone in the room here. No, where we actually have a couple of those emails, and they don't know we have them yet because they haven't asked for an affidavit of documents. I'm about to cross-examine them. And, well, needless to say, it's going to make for some exciting fireworks at the cross-examination. So when you're doing the requesting of an affidavit of documents, or when you've received one, don't just say, oh, isn't that great, and give it to your clerk and say, do an NFP statement. If there's an issue of disclosure, or if there's an issue of whether the person's income is what it is, and if your client has said to you, you know, they always kept all their records on their laptop, well, then there's probably documents missing. In fact, I'm willing to bet dollars to donuts there are. Now, whether they really show the smoking gun, that's a different question altogether. So in terms of the document discovery, you have to think about what are documents, how to get them, and how to follow through on them. Now, the rules are a little bit different because under the rules of civil procedure, it's mandatory that after you close pleadings, you have to produce an affidavit of documents within 10 days, which is always honored in the breach, and that's not surprising. But you can compel someone within a reasonable period of time to get an affidavit of documents. In order to invoke the rule under the family law rules, you have to make the request. So write the letter saying, can I have your affidavit of documents? That invokes the 10-day rule. Again, I don't think really 10 days is likely to ever be seriously enforced. First of all, getting a motion within 10 days in most of the family law rules jurisdictions is almost impossible. But the point being, if you're concerned about disclosure, if you're concerned about getting your trial ready without having to do a discovery, there's nothing wrong with making the request. Get the ball rolling so that you get your disclosure. Of course, privilege protects certain documents, but under the rules of civil procedure, although not in a separate category under the family law rules, you still have to disclose those documents. And the question of whether they're not privileged, they are or not privileged, is for another day. The failures of anyone to obey either of the rules are very similar consequences, of course. If you don't disclose everything, and then at trial try to put in a document that was supposed to be part of an affidavit of documents, it probably won't go in. Unless, of course, the document was just found, or you can justify the reason it wasn't disclosed earlier around that kind of issue. So it's very important also when you're bringing your own affidavit of documents to bear that you be sure that the disclosure is complete, because you may be precluded from what you thought was a document was either irrelevant or perhaps harmful to your case that you were alleging was privileged, to then turn it around and make it a non-privileged document. Remember, the purpose of the disclosure is to allow the other person to learn their case. If they're only finding out, 2 days into the trial that there's this document, judge is not going to be happy with you and is probably going to make some difficulty regarding that document going in. The other thing to think about when it comes to disclosure of these kinds of documents is if you just find a document, don't sit on it and wait. Send it over to the other side right away for the same reasons. And I know of a case that's now ongoing, which has now been ongoing for 4.5 months in a civil context, that virtually every day there are mountains of disclosure coming out in the middle of the trial, which may sound completely inappropriate, and you get all outraged about how can I conduct a trial when I'm getting documents sent to my office while I'm conducting the examinations. But the reality is, if you want the documents in, at least make that effort to disclose, and then the issue of cost, do we have to adjourn the trial and all that, can be dealt with in the normal course. I'm going to turn quickly now to requests to admit, because again, I think disclosure is a relatively straightforward proposition, and the steps you have to take are well known. The request to admit is an underutilized tool, and Georgina, again, she mentions this in the context of a discovery under the new rules and whether or not you need one. Now, I'm as guilty as anyone thinking, gee, I'd like to do 10 requests to admit, and then finally, sort of 21 days before the trial, you go, okay, I'll set up my request to admit now. That does you no good, of course, 21 days before, because the whole purpose of the request to admit is to narrow the case so that you understand the case that you're going to be meeting. And so doing it 21 days before trial may satisfy the rule which requires the answer within 20 days, but it doesn't necessarily actually satisfy your need to understand the case or to pin them down. Finding out the day before trial something really significant is not being admitted can be a little bit difficult to manage it actually at the trial. Now, the cost consequences are also well known about if you answer and deny something and it turns out to be true at trial, then you can create some problems for yourself or for the other side around costs. I've always had difficulty when arguing costs on these issues, persuading a judge that this is monumental or significant, unless it's something that is so important, perhaps the date of separation, right? Where you have a 3-day trial, and it was so obvious to the judge that this trial wasn't necessary because the husband or the wife had backdated it 10 years, and you made the request to admit, and they denied it, of course, early on in the proceedings, and then you're sitting at trial and you have 3 days of evidence, and then boom, you win. And then, of course, the NFP's all been done because you did disclose each date of separation documents back and forth, and we all know what the numbers are. We're just fighting over date of separation. That one little question can mean everything to you at the trial, even if your NFP isn't so great. It's quite remarkable how judges react to that kind of thing. So don't be afraid to use it in that context as well. It says under the rules you can use it at any time, so there's nothing precluding you from doing it on a motion. So long as it's 20 days in advance, you might be able to argue on the motion. You should be able to argue on the motion that this was unnecessary to have, or these facts were unnecessary to prove, and you've made these findings. I want costs. Even if you lose the motion, ironically, you could argue costs. Even if the result was a higher child support award than you expected, but everything else fell in your favor, you might be successful in arguing at least no costs because of the steps taken to prove what you didn't have to prove otherwise. One little thing that I didn't notice until I was preparing for this, and was that under the rules of civil procedure, you can withdraw an admission at any time, provided there's consent or leave of the court. Under the rules of family law, it's only with the court's permission. Now, I guess begs the question, if you did a consent order requesting such a withdrawal, whether or not the court would simply rubber stamp that or not. But it's an interesting little difference between the rules that I think you should draw your attention to. Another interesting thing is there's a case called Canpotex and Graham, which is a fairly old case, 85. But it has an interesting principle around the request to admit that you must take note of when you receive one, or even when you're sending one out, but more so when you receive one. The summary that I've written out here is as follows. A response to a request to admit should be based on the truth of the fact or the authenticity of the document, and not whether the fact or document is admissible in evidence. So the question of admissibility is not the question. It's the truth. Whether it becomes admissible or not is a question for the trier of fact. And that's a significant issue, and I've always wondered if I asked a bunch of privileged questions that were quite pointed about, for example, hiding assets or income, and there may have been emails exchanged between the lawyer about what the real income is. It begs the question whether or not you have to A, disclose that, and B, once you've disclosed all those emails, whether or not, from a request to admit perspective, you might be able to say, hey, I now know that evidence to be true because they disclosed it to me. And then the question of whether or not you can get it in. It's an interesting question I've never actually tried myself. In your request to admit, be very specific about your questions. Don't ask general questions. And if you look at the materials, I'm not taking you there, but if you look to the materials, they give you some examples of very specific kinds of questions. Because, of course, you don't want the question, the answer to be of such a general nature that is of no help to you. Why bother write the question at all? So, to summarize, the other thing is, the last point on the issue of documents that I forgot to tell you about. When you receive documents, and we receive them in different fashions, sometimes, as Georgina had mentioned, you receive the documents because I write a letter saying, do an NFP brief, I get it. And then I send mine out. And then you realize it's really not going to settle, so then you do an affidavit of documents. I find it very important to take the documents, and as they come in, I put them in a separate file folder, and our firm is famous for colored folders. You know, blue is for husband and pink is for wife or whatever. And we know both when the document came, who sent it, because sometimes it gets all jumbled up, and at some point, sometimes these things are very important. So even though you may have the document 6 places in your file and feel like you're carrying this gigantic elephant around with you, you never know who it came from, and when it came may become very significant. I've had it happen to me a couple times in trial where the judge asked the question, well, who produced this document? And both counsels sort of blankly look at each other saying, I have no clue. You know, we did all these exchanges, and then, of course, my clerk says, well, it was in the pink file, so it came from the wife, and we're acting for the husband. Boom, we know, and we have the date. So that's something that can become useful to do, so from an organizational point of view. So for the most important quick tips on document disclosure, one is relevance. Is the document relevant? Number 2, organization. Number 3, is it a document? So ask yourself the question, is it a document or not? Or tell your client, these are documents. Fourthly, disclose even up to the eve of trial if something comes into your hands that you never had before. Better have the fight about whether it can go in or not, but do not be one sitting on a document and then have you looked at later for not having disclosed it. And then, of course, whether it's privileged or not. And then on the request to admit, I have only 3 things. Do it early and do it often. Don't be afraid to use it on an interim motion. And this is the most important thing, and this is for Eva Frank's benefit a little later on today. When you get a request to admit in, always do it as soon as it arrives. It takes 20 days. 20 days seems like a lot. It is a really short period of time if it's a good request to admit done. If you think you're not going to make the date, immediately write the other side and ask them for an extension. If they say no, bring a motion. Because the consequence of a failure to admit is an admission. And an admission means a motion for judgment. And I've had it done on me, and I've done it on others. And you've got to be very, very, very careful. Thank you very much.
Thank you. We'll just take the break, about 15 minutes.